and with another edition of the Privacy Corner with Privado AI. And this week I'll be talking about a very interesting EU Advocate General opinion that suggests that free newsletters, white papers, and other kind of lead generation tools could be sent without consent. New draft CCPA regulations that have stricken behavioural advertising from the automated decision-making technology rules. And the UK is reportedly developing a murder prediction AI tool. So we'll see if that's as terrifying as it sounds. So first up, this EU Advocate General opinion is about a Romanian company called Inteligo that publishes daily legal updates, and users can access 6 articles on their site without paying or registering. If they want more, they have to sign up for the free freemium service, and this requires them to give their email address and agree to the terms of service. So premium service users get an extra 2 articles each month, a personal update newsletter that's free, and access to the archives and various other paid options. And the account creation form provides an opt-out. It's not pre-ticked. It says, I do not want to receive the personal updates. Every email, of course, includes an unsubscribe link. So what's the problem here potentially? Well, under Article 13 of the EU Privacy Directive, EU member states have to implement the following rule into their national law. This is insofar as relevant to Inteligo's case. There is more to this. So unless an exception applies, publishers cannot send business-to-consumer direct marketing via email without consent. The standard of consent derives from the GDPR. Now, that rule does not apply if, among other things, these are the relevant bits, the publisher has obtained the person's email address in the context of a sale of a product or service, in the context of the sale, and they only use the email address to send direct marketing of their own products or services. So the Romanian Data Protection Authority found that Inteligo should have got consent to process personal data with a view to sending these personal updates, and it issued a €9,000 fine under the GDPR Articles 51A, 61A, and 7, so all these things about consent. And the decision was upheld partly, the fine was lowered, both sides are appealing, it ended up at the CJEU. So the Advocate General opinion on this case, first question it tackles is, was this personal update direct marketing? So in this case, Inteligo wants it to be direct marketing, so they can benefit from the consent exemption of the e-privacy directive. The Romanian DPA said it wasn't direct marketing, and so they couldn't benefit from that exemption. It's a kind of strange sort of backwards situation, arguing that something isn't direct marketing and therefore you've broken the consent rules. In the end, the AG agrees that this is direct marketing. It's a way to kind of entice people back to the website, use up their credits. And so he says that, in theory, the direct marketing consent exemption was open to Inteligo here. Next, did Inteligo obtain the email addresses in the context of a sale? Remember, this is a free service. The Advocate General says yes. Remuneration of a service does not have to come from those for whom it is performed. So in other words, even if these users aren't paying, it's still a revenue generation technique from Inteligo. And the AG also says data is treated as a commodity and people can exchange their personal data for goods and services. They even quote Economist article here with that lovely phrase, data is the new oil. So we're seeing this kind of language quite often from the CJEU. Remember, though, this is just the AG opinion. So which legal basis should Inteligo have relied on if not consent? Well, the AG says no need for any legal basis. Recourse to the GDPR is neither possible nor necessary. In fact, the e-privacy directive comprehensively governs the conditions and purposes of the processing, the rights of the data subject, and specific obligations on the controller. So this also meant, in the AG's opinion, that the fine should not have been under the GDPR, but under the e-privacy directive, if any. In this case, no fine needed because Inteligo did everything right. So if you're offering free newsletters, white papers, other kind of lead magnet type stuff for free, this could be encouraging. But remember, this is just an AG opinion. The CJU, I think, could could uh, could disagree on some points here. Next up, over in California, the California Privacy Protection Agency has revised its proposed regulations on automated decision-making technology, ADMT. So these have been in the works for a very long time, and the definition of ADMT is important because if you're doing ADMT or using ADMT, there's a lot of stuff you have to do. The CPPA seems to want to align this law with the Colorado AI Act, which takes effect next February. And these amendments could mean less work for a lot of CCPA covered businesses. So the CPPA's ADMT rules would require some pretty extensive compliance work from businesses covered by the CCPA. And there have been a lot of modifications to this batch of regulations. So the first draft only spoke about possible discussion of the inclusion of behavioural advertising in these regulations. Then it was in, now it appears it is out again. So we do have things like access to services, work or educational profiling, but not behavioural advertising. This, of course, means that consumers lose a bit of transparency here because the ADMT regulations require you to give a notice on collection with certain parameters, require human oversight and opt out and so on. Alistair McTaggart on the CPPA board says that we are now on notice that if we pass these regulations, we will be sued repeatedly and by many parties. So it looks like the California Privacy Protection Agency is very much aware of the litigation environment around the CCPA. Finally, in the UK, the Ministry of Justice is developing a tool to predict who might commit murder. So these proposals were published by The Guardian, and they come from Freedom of Information requests from the NGO Statewatch. The project was originally called the Homicide Prediction Project, now something much drier and more boring, and it uses police and government data to profile people and identify those at risk of committing a murder in the future. Statewatch argues that the tool will include data about lots of people, some of whom have not been convicted of a crime. The government insists it only includes data about people with criminal convictions, and it's just a research tool for the time being. So Statewatch got some pretty interesting stuff out of this FOI. We have a DPIA, we have a internal risk assessment, we have a data sharing agreement between the government and the police force. And the data appears to include things like names, dates of birth, gender, ethnicity, police national computer identification numbers, details of criminal convictions, age, first interaction with police, indicators around self-harm, mental health, addiction. The idea is that the model will see patterns in this data and be able to predict who might become a murderer. Of course, under the EU's AI Act, I think this would probably amount to a prohibited practice. This project started last year in the UK under the Rishi Sunak government, and of course, the AI Act does not apply in the UK. So the government assures us that there will be more information about this in time, and that for now it's just a research project, but some pretty creepy and interesting stuff. Do take a look at what Statewatch got hold of. I'll leave a link in the newsletter. Well, that's all from me this week. Thanks so much, as always, for tuning in, and thank you again to Privado AI. I'll see you next time.